MSW Media.
I signed an order appointing Jack Smith.
And nobody knows you.
And those who say Jack is a fanatic.
Mr. Smith is a veteran career prosecutor.
Wait, what law have I broken?
The events leading up to and on January 6th, classified documents and other presidential records.
You understand what prison is?
Send me to jail.
Hey everyone, welcome to Jack, the podcast about all things Special Counsel. It is Sunday, September 3rd, 2023. I'm Allison Gill.
And I'm Andy McCabe. All right, AG, in the DC case, we have a trial date set by Judge Chutkan of March 4th, 2026. No, I'm just kidding. It's 2024. 2024. Along with a full trial schedule. There's also reporting that the prosecutors on Jack Smith's team were asking questions about Rudy Giuliani's drinking and level of inebriation while advising Trump leading up to the events on January 6th. And we have some more information on Republican efforts to defund the Special Counsel.
Oh, they never stop. They started doing this back in the Mueller days, and they haven't shut up about it. We also have the curious case of Harrison Floyd, and you and I have spoken at length offline about this, and it's just an interesting, weird story. But what it has unveiled and what's pertinent to the Jack Smith investigation is that we now know that Jack Smith was investigating the intimidation of Ruby Freeman in Georgia, or at least trying to subpoena Harrison Floyd for whatever reason. I'm assuming it's the Ruby Freeman stuff in his investigation into January 6th, not just down in Georgia. And then in Florida, we have a speedy trial invocation from Carlos de Oliveira. That's weird. We'll talk about that.
Yep.
It went way under the radar. Nobody really reported on this. It got dug up by a listener who sent it to me and said, "Did you see this?"
Nice. The MSW Nation at work. I love it.
Yes, our sleuths hard at work. And we have 7 redacted search warrants released with focus on Walt Nauta. And going back to D.C., let's start there, Andy. I was in Judge Chutkan's courtroom this past Monday for the trial date hearing.
That is amazing. I'm so glad you went in there, and I can't wait to hear all the things that you saw.
I almost didn't make it in because I was carrying my phone and they're like, ma'am, step aside, out of line, get out of line right now. And they looked at my photo roll to make sure I hadn't taken any photos.
No way. That's
the
super
courthouse.
Paranoid. I'm even very familiar with paranoid court officers. They definitely, don't want you taking the phones in there or the guns. In my case, that was always a bigger problem. But
and then when I sat down, I was like, "Hey, can I go sit next to my friend Harry Dunn?" They're like, "Ma'am, just sit where you are." They were really already done with me. I should have worn long sleeves, maybe a blazer. Should have looked more professional, I guess. Maybe the nose ring. I don't know. But anyway, I got into the courtroom, and I'll paint the picture for you. On the left is the prosecution table. Defense table was on the right as you face the bench. The prosecutor's table had Molly Gaston and John Wyndham. Now, we know John Wyndham was appointed to investigate the tippy top of the coup way back in November of 2021. I know all of the pundits on TV want to say that they didn't start investigating until April or May of the next year, or until after the hearings happened for the January 6th Commission in June of 2022. But he was appointed to investigate Trump in November of 2021. And you'll remember he tried to issue subpoenas for the Willard, fraudulent electors, Clark, Perry.
He's the guy that had to struggle with a lackluster FBI response out of the
Eastman.
Washington field office, and had to scrape up some IG investigators and postal dudes to do his work for him, there's a story to be told there. I can't wait till we get to the bottom of that.
Yeah, and we have an episode in the past called the Search Warrant Two-Step, where we were trying to figure out why on earth the Inspector General was confiscating these phones. Well, now we know. It's because Dan Tuono at the Washington field office, the FBI, was refusing to approve those search warrants and subpoenas. So Wyndham was there at the table. He is the lead prosecutor on this particular case. Jack Smith sat behind them in the gallery, and he was flanked, Andy, by 6 security guards.
Wow.
6. Now, Harry Dunn was one row behind Jack Smith, and I'm behind the defense table, which had John Lauro and Todd Blanche.
Mm-hmm.
I was behind them, diagonally behind Jack Smith. I had a direct line of sight to Jack Smith. So I kept my eye on him. He mostly just stroked his beard and was the whole time.
Very pensive. Was he wearing the robe with the purple stripe on it?
He should just wear that everywhere.
I feel like he should just roll in with that. Like, I'm here.
You know what would be great is if he had a T-shirt with that printed on it. So it's not even the robe, but like a tuxedo shirt.
The tux shirts. You got there before me. Oh my gosh.
Yeah. Now I want one of those shirts.
Hey, all I know is Halloween is coming. I know what I'm going to be.
Oh, that's so funny. Grow the beard.
There you go.
And so that's where I was situated. I was watching him the whole time. Now at the break, we did stand up. Jack Smith was facing the gallery, facing us and away from the bench. And I looked at him. We made eye contact like for a minute. And then he gave me like the sup, like the head nod.
He's like, how you doing?
What's up? And, 6 security guards around him. And I was like, when that happened, I told everybody about it. They were like, oh, he knows who you are. And I'm like, probably his security does and was trying to keep me away from him because I'm the crazy lady with the podcast just about him. I have Mueller tattooed on my arm. So like they were probably like, all right, she's a little...
She's on our side, but a little over the top, we think. You should have given him like the heart hands, the fingers and the heart.
Well, I certainly couldn't take a selfie with him because I would have been kicked right out of that courtroom. Now, the judge came in, gave some opening remarks, including neither proposed trial date, which was January 2nd of 2024 by the DOJ and April 2026 by the defense. Neither were appropriate. She reminded the parties that the right to a speedy trial doesn't only belong to the defendant. It also belongs to the public. And that the longer it takes to go to trial, the more chances of tainting a jury pool, especially from inflammatory posts by the president, former president, and the danger of memories fading, right? This is why when people asked Bob Mueller, if you couldn't indict Trump, why did you investigate? And his answer was to get the facts and the information in the testimony while they were still fresh in the minds of the witnesses. That always stood out to me. And so she brought that up as well. She stated that Mr. Trump, she wouldn't call him President Trump, and Mr. Trump's day job has no bearing on the court or its schedule, and it wouldn't for any other defendant. She even used an example saying, like, let's say there was a criminal defendant who was a professional athlete. I would not take, she goes, I would not take her schedule into consider. I was like, her, nice, all right. Women rule the world.
I love both of those points. The piece about the public having an interest in a speedy trial is so important and I think over or under focused on. And this kind of punching through this myth of like, oh, because he's chosen to run for president, he should get a completely different treatment from the system. It does not work that way. It should not ever work that way. And I'm glad to see it's not going to work that way in her court.
Yeah, she was basically saying, look, everybody's got shit to do. You're not special. You're not the first person in here with a day job. Thank you. And she started to address the arguments. And the first thing she touched on, which is something we spoke at length about, was this myth that Title 18 U.S. Code 371 cases take an average of 29.4 months to complete. She brought up the fact that this was misleading. She called it misleading. She said that is a number that reflects from commencement and indictment through sentencing, not to the beginning of trial. She also brought up the fact that, that wasn't the only consideration. She said the defense only used cases from 2021 and 2022, which was a handful of cases, 22 cases, and they were all impacted by COVID backlogs.
Right.
She also pointed out that the defense used cases with multiple defendants, 5 to 17 co-defendants, cases with pretrial detention hearings, some very, long pretrial detention hearings. Many of these had superseding indictments and plea negotiations, lengthy plea negotiations. She's like, none of that is true here, and reminded everyone that this is one defendant and 4 counts. And that is so important because that, I think, was Jack Smith's gambit of having a simple indictment paying off. Totally
agree with you. And as proof, you see what's happening down in Georgia. the chaos that comes along with a 19 defendant case. It's unavoidable. I'm not throwing a rock at Fani Willis, but she made the decision that she wants to put on this incredibly broad case against all this broad scope of people. This is the baggage that comes along with that. Some speedy trial, some are delays, federal removal, this, that, and the other thing. So I think Jack Smith very intentionally chose to avoid all that and kept it clean and tight on the person who's most responsible, stayed away from things like the insurrection charge that might bog down, the prosecution in never-ending arguments about First Amendment rights and everything else. And we're seeing that pay off now, even with the scheduling order.
Yeah, and I wanted to take a minute here to discuss with you. A lot of folks seem to be very upset that none of his co-conspirators have been indicted. None of the people in Congress have been indicted. No one else has been indicted. Roger Stone, Mike Flynn, Steve Bannon. None of these other people have been indicted for January 6th by the Department of Justice. And I wanted to raise the possibility that by doing that, you could complicate this case, much like the Fulton County case is complicated. Because if you start indicting his co-conspirators, they could start filing to consolidate with the Donald Trump case and adding themselves as defendants to the Donald Trump case. And therefore pushing it back, making it more complex, or trying to file motions about how to be different, or, other things that would have to be considered. It is very feasible, and you and I have spoken about this in previous episodes, and I think a lot of people are now starting to pick up that conversation and roll with it. I could see a scenario in which Jack Smith will indict other people, but not until after this case is over. He's got plenty of time on his side to do that. There's no election consideration for anybody else. And the statute of limitations wouldn't be up until 2025, 2026. So
that's right.
I would personally, because this is such a huge factor, the simplicity of this case is such a huge factor in getting this done quickly, getting it done before even the Republican National Convention, that he would try to indict anybody else. And I would support that decision. I mean, I know he doesn't call me he looked at me in the courtroom, but I don't think he was looking for my permission to not indict anybody else until after this is done. But I'd be happy to wait until it was.
I see it the same way that you do. When you're planning a prosecution of either an individual or a group of individuals, there's a million things to be considered, and everything from strength of the evidence to your cooperators and how good or bad they might be, and other proceedings going on at the same time, and timing, all kinds of things. It seems to me that in bringing this case the way they did, Smith's team prioritized their number one priority was getting this case brought in time so that it could be tried in time to be finished before the election. And the best way to do that was keeping it clean on one defendant, the only defendant, potential defendant for whom the election had any relevance. So all of those other people, now there are downsides to that, right? If you plan to go back and indict some of these currently unindicted co-conspirators at a later date, they are now going to get a preview of the evidence against them. They may even get to see the evidence. If there are violations in the protective orders, they might see evidence from the Trump's attorneys about, different things that the prosecutors have against them. Those are all calculated risks that the team is prepared to take in an effort to focus on the top priority, which is getting this case against Trump in court, heard and resolved before the election. And, how can you argue with that prioritization? That is the most important thing right now, to give people the opportunity to hear this thing, to hear how the case comes out, to hear what the evidence is, and to hear the decision of the jury before they have to go into the voting booth and make a decision for themselves. So, yeah, and I think that if you're taking any shelter or comfort as an unindicted co-conspirator from the fact that you haven't been indicted yet, you're kidding yourself. Because this thing could go on for years. He could be rolling up lower and lower people in follow-on prosecution after follow-on prosecution for years.
Yeah, and it's the same with the wire fraud stuff. He could bring superseding indictments,
Absolutely.
But you're going to tack those onto this case, and you could run the risk of extending it into and or past the election. Those things can go later. I really do think.
Hey, Trump could get indicted for more stuff later, right?
Right,
Whether
that's what I mean, like that wire fraud.
Right.
And,
acquitted or convicted on these charges, he could get hit with other arguably less important charges later. But again,
or bigger charges. He could be charged with seditious conspiracy or incitation of a riot. I mean, the things separate from the specific behaviors outlined in this case. But I think maybe because they used the riot as part of this conspiracy against rights, that's probably off the table, like a double jeopardy sitch. But, there's all sorts of considerations that I honestly think Jack Smith is going to be waiting. So if people are waiting for these superseding indictments for either Donald Trump or his co-conspirators or anybody else in the periphery of these crimes, you might be waiting a while. And I think that would be for a good reason. I just wanted to bring that up.
I agree.
All right, then they addressed the volume of discovery, right? And it was 11.3 million documents. Now it's up to 12.8 million pages, not documents.
Mm-hmm.
And Molly Gaston argued that even though there's 12.8 million pages, 61% are things that are public, that Donald Trump has had access to, or that Donald Trump himself created. 61%. Now, and of the remaining, a lot of it is duplicative. She argued that the DOJ has gone to considerable lengths to organize this discovery, more than probably any other defendant in history, including coding and filing and Bates numbers in groups and, annotations on things. They have about 45,000 key documents for the trial, and they put it in an annotated version of the indictment to provide a roadmap to discovery. They have timestamps on relevant surveillance footage. And by the way, when she was describing the great lengths, and the judge acknowledged the great lengths that they went to organize this discovery for the defense, that's the only time I saw Jack Smith react, and he just nodded his head twice. So I thought that was interesting.
It's really interesting. And I have to say, I mean, to be perfectly fair, I think that this is their weakest argument in this whole back and forth. And here's why. 12 million pages is 12 million pages. I don't think that Trump's argument that the size of the discovery is a reason to delay the trial. I don't
or
agree with that. Or
that they have to look at it page by page.
Right. But some of Molly Gaston's reasonings here kind of falls a little bit on deaf ears if you've been through this before. No matter who you are and how well the prosecution gives you a roadmap and tells you what's most important, you still have to look through all of it. You're never going to be completely comfortable letting the prosecution tell you what documents that you should base your defense on, right? You're always going to have to go through that stuff to see. There could be little Easter eggs hidden in there that are exculpatory or, could be beneficial to you in cross-examining the government's witnesses or whatever. The other argument that like 61% are things that were public or created by Trump. Yes, but he didn't really have any obligation to be reviewing that stuff or preparing his defense before the case was brought, right? So you still have to go back and analyze all those things in the context of this case and the things he's been charged with. So I don't know that those arguments are that persuasive. However, 12 million page cases that run through 12 million pages of documents happen every day in this country in federal court. And there are immense resources available to defendants who have resources. And this defendant has resources. So he can get this done if he's got to hire more lawyers or hire e-discovery companies to help him sort it out, hire more paralegals, whatever, he can do that. And we can still get this trial done on time.
Yeah, and that's why Judge Chutkan, in her response, she hammered home on the not necessarily the, any of the other arguments that Molly Gaston made, but the argument that these are searchable by keyword, and we have whole industries now, a whole cottage industry of businesses that do this for a living. In fact, Mr. Trump, you just spent $350,000 so Rudy could do this.
That's right.
Through Trust Point. She didn't bring that up, but yeah, we were all thinking it. So that was her main reasoning for this trial date, and why the Department of Justice's January trial date was not appropriate. So, I think that was very interesting. She also argued a lot of discovery is duplicative. She gave an example that all of the testimony is annotated with evidence exhibits,
mm-hmm.
and those evidence exhibits are also submitted separately. So those are all duplicates. She notes that the 3.1 million Secret Service emails, that accounts for like 20% of this.
That's
whole
amazing.
Discovery. And a lot of that is also duplicative. And we also learned through this process that there are roughly, Andy, 250 potential witnesses.
Wow.
Which is quite a bit. Then Lauro got up, and he was yelly and raising his voice, arguing Sixth Amendment rights. You can't do this to my client. And so much so, he was so yelly that the judge asked him to take the temperature down twice. He continually brought up Judge Chutkan's experience as a criminal defense lawyer, saying, you know me, you know what I'm trying to do, you understand. And he did that multiple times. He kept referring to Trump as President Trump. One time accidentally referred to him as Mr. Trump and corrected himself.
That's to make sure he doesn't get fired. A couple of Mr. Trumps, I mean, he might find himself out of a gig.
Yep. And he wasn't able to articulate why exactly a 2026 trial date was necessary, like with math or anything. And so the judge said this isn't going to trial in 2026, and that the indictment of Trump shouldn't have come as a surprise to you. That's what she said. It's not like, surprise, you're indicted.
Yeah.
I thought that was interesting.
What? Are you kidding? Yeah. I got indicted for what?
And he brought up all these potential pretrial motions he plans to file, including selective prosecution, executive immunity, First Amendment considerations, Rule 17 subpoenas. And he said, these are all novel legal arguments, Your Honor. Novel legal. These are brand new. No one's ever done these before. And that's when Molly Gaston said, these are not novel. 1512 and 371, we have tons of cases. It's not new. Selective prosecution, as she goes, especially in D.C., is not new. This has been argued to death. Executive immunity, not new. We've been doing this for a while. The First Amendment certainly isn't new.
Yeah.
Just all sorts of. She's like, none of this is novel. It's one guy. It's four counts. And then the SEPA considerations, just as you and I had predicted, and we talked to Brian Greer about this. Those can be run in parallel. There's only about 300 pages of classified information in this case that will head over in discovery, and none of it is part of their case in chief, which means they're not going to be using it in their presentation of the prosecution.
Right.
They may need it to rebut defense or just for you to have. And the only argument there was that Molly Gaston wanted a 30-day deadline to file Section 4 SEPA motions after Todd Blanche got his full clearance. He's about to get it. He might have it now. It could be any day. And Blanche got up and argued that he wanted to wait for that 30 days clock to start ticking until after Lauro got his full clearance. And he hasn't even, I don't think, applied for an interim one. So the judge was like, no, you can look at the 300 documents. They're not being used in the case in chief. And an interim security clearance that he should have by then, Lauro should have by then, is enough for you to discuss these documents with him. So she turned that down and granted the DOJ that 30-day thing and said it can all go in parallel. And then that's when Chutkan said, okay, March 4th. And we all sort of in the courtroom were like, yeah, because we guessed. That's what our guess was. Everybody was guessing March.
Was it a woo woo, hands in the air, or no? It was more.
There was like an
sedate.
open the fridge or like a little fist pump, but nobody made any sounds because you don't do that.
No.
I was already like on the edge of being kicked out of the courtroom.
You knew you were going to be the first one out if things went crazy.
Totally. Yeah. Absolutely. And so then Lauro got up and went on the record saying, this infringes on my client's Sixth Amendment rights. This is unconscionable. You know better. You're a defense attorney formerly. You should know, blah, blah, blah. I just want to go on the record so he can appeal later,
Sure.
But the thing was, he invoked something called the Scottsboro case. And Judge Chutkan specifically called him out for this. This is a 1930s case about 9 black men who were indicted for raping a white woman. And they were indicted, arraigned, and went to trial within 6 days. And they didn't get representation, like anything. Right. And she was aghast that Donald Trump would compare his case and his prosecution here to that of the Scottsboro boys, because 6 days and no resources. She brought that specifically up and said, basically GTFO in my courtroom with that. She was very upset by that.
I cannot for the life of me, figure out what they're trying to accomplish. It almost seems as if they figure, you know what, she's not going to like us, so let's just go down in the biggest ball of flames that we can possibly put together. It started with the first appearance where he claimed, I can't possibly represent my client sufficiently, and he's going to have a motion for insufficient assistance of counsel. Then they come in with the 2026 trial date request, which is on its face ridiculous. I don't care how big of a defense attorney you are. There was, he couldn't even specifically defend that date. And now the Scottsboro reference, like, anyone in their right mind would know, like, that is not going to land well with this judge. Why are you trying so hard to piss her off for no reason? I feel like there's got to be a strategy behind this, but I can't for the life of me imagine what it is.
No, yeah, it's because we're not weird. So
I guess not weird enough.
We can't figure out why you would do that in this particular case. But
you have so much to lose as a litigant if you piss the judge off right at the beginning. And it comes down to every little motion. Every time you object to a piece of testimony in the middle of trial, whether or not that objection gets sustained or dismissed, oftentimes comes down to the way that the judge perceives you and the reasonableness of your arguments historically. And, so by kind of heaving your credibility out the door on day one, you just automatically put yourself in kind of on a losing footing in ways that can really matter later on. Most attorneys go out of their way to try to develop some sort of relationship, respect, whatever with the judge, but not this team.
The only thing I could think of is that they're pissing her off to get her to do something that they can later appeal. You know what I mean?
Yeah.
Like he's been trying to poke her to get her to issue a gag order. I'm like, she's not going to issue a gag order.
No.
And so maybe they're just poking her to try to get her to do something that's, I don't know, that they can appeal later. That's the only thing I can think of.
Could be. We'll see. See how that's going to go for them.
Anyway, it was really, really interesting being inside that courtroom, and I'm glad that I got the opportunity to. Everybody who was in line, by the way, and the public got to go into the courtroom and watch it. I think it's awesome if you live in the area or you're in the area, you get a chance to go to the D.C. courthouse, head down and, sit in on a court hearing. Don't bring your phone and or keep it in your purse or your pocket. Or go see a naturalization ceremony. I've heard those are very moving. But it's really interesting to see that the judiciary in motion.
Yeah, totally agree. And in this case, look, it's history. One way or another, like it or don't, it is history making. And to be able to see it one day as it's happening, that would be something you'd never forget.
Yeah, truly. I might show up in March, but I think the lines might be a little bit longer.
A little longer, yeah, for sure.
All right, everybody, we have more to get to. Stick around. We're going to talk about Rudy and his drinking habits after this quick break. We'll be right back.
Welcome back. Okay, next up from Rolling Stone. Special Counsel Jack Smith's office has repeatedly grilled witnesses about Rudy Giuliani's drinking on and after Election Day, investigating whether Donald Trump was knowingly relying on an inebriated attorney while trying to overturn a presidential election. So in their questioning of multiple witnesses, Smith's team of federal investigators have asked questions about how seemingly intoxicated Giuliani was during the weeks he was giving Trump advice on how to cling to power. According to a source who's been in the room with Smith's team, one witness's attorney and a third person familiar with the matter. So that's 3 sources on this line of questioning.
Yeah.
They go on to say the special counsel's team has also asked these witnesses if Trump had ever gossiped with them about Giuliani's drinking habits and if Trump had ever claimed Giuliani's drinking impacted his decision-making or judgment. Federal investigators have inquired about whether the then president was warned, including after election night on 2020, about Giuliani's allegedly excessive drinking. They've also asked certain witnesses if Trump was told that the former New York mayor was giving him post-election legal and strategic advice while drunk.
Oh. Now, when I first read this, everybody's take on this, including the folks at Rolling Stone, is that they're trying to establish that Trump knew he was taking advice from an inebriated person. My first thought was that they were trying to establish a defense against Trump saying, hey, he told me this was legal. He was drunk. I didn't know he was drunk. And now they're trying to prove that he knew and that everybody knew he was drunk. We saw Jason Miller testify to the January 6th committee and others that Rudy had been drinking. But, Jason Miller specifically said, I do not know if he spoke to Trump in that condition or whatever, or advised Trump in that condition. So it felt like a prepping for a defense to me. But, something that would be used in response to something. I don't know. What do you think? Do you think it could be characterized as they would come out of the gate saying he was taking advice from drunk people and knew it?
I tend to see it more from your perspective, but let's just start at the beginning here. There is no legal defense. Sorry, my attorney was drunk. Therefore, I'm not responsible for these crimes. That's not a legal defense in the United States of America. If it was, even more lawyers would be drunk all the time. So this whole thing is very strange to me. They wouldn't be asking these questions unless they had some very specific concern about it and how Giuliani's possible drunkenness in these key moments might impact their case. My sense is more like yours, like somehow it's come to their attention. They may have had a witness. I'm totally making this up for the sake of argument, but let's say a witness comes in and says, well, Trump told me once he can't be responsible for anything that Giuliani told him because he knows Giuliani was drunk all the time, right? So if you're thinking that maybe the defense puts on a witness like that to lay this little bomb out there in front of the jury to try to go for jury sympathy or something, then you would want to drill down on it and find out if other people had ever seen or heard Trump acknowledge the fact that Giuliani was drunk a lot. Because then you could say, well, it doesn't matter because you knew he was drunk. You took his advice anyway. So it's almost like a rebuttal line of questioning, right?
Yeah, or like even a Rudy defense. Like, I can't be held liable for entering into a criminal enterprise when I'm inebriated. Like some sort of contract thing, how you can't.
It's so absurd. That doesn't work on any level for any offense. Like, if you
I was
allowed
drunk, so you can't arrest me for drunk driving.
Right.
I couldn't have possibly made a good decision about whether or not to get behind the wheel, so I'm immune.
How was
from
I
your
supposed
DUI.
to not to drive after I'd had 12 beers? I'd had 12 beers, for God's
How
sake.
was I supposed to know you're not supposed to coo?
Oh my gosh.
I'm just trying to figure it out. Like, what could it possibly be? Yeah, sometimes maybe it just came up and they want to follow it thoroughly to the end so that they have all the information in case it pops up at trial and they have.
Or maybe it was just fun to ask the questions. I don't know.
Multiple witnesses.
They're just curious. They're like, come on, could this be a real thing? Yeah. I don't think that there's anything to this substantively. There's no, but for my besotted attorney, I wouldn't have violated any laws defense. So yeah, I don't know how this one's going to play out.
I like "but for my besotted attorney." I think that's a good episode title. All right. So now the curious case of Harrison Floyd.
Mm-hmm.
You and I have spoken about this a little bit. He's one of the 19 defendants down in Georgia. He surrendered on Friday like he was supposed to. But he was remanded. He was kept in jail until the following week at the Rice Street Jail in Fulton County. And when he got out, Steve Bannon helped him raise a bunch of money to make his bond and get out. When he got out, he went on the Steve Bannon show and said, I'm the only one they held behind because I'm the black guy. And then Fani Willis released an audio tape of her phone call to him on Friday when he surrendered, offering him a consent bond that he refused. So he stayed in jail that weekend because of himself and his refusal to accept a consent bond. And so, but then this other whole thing about earlier this year, he was arrested an affidavit went in, warrant out for his arrest, because he assaulted FBI agents who were serving him a federal grand jury subpoena in Jack Smith's investigation. So the story here and how this connects to Jack Smith is just that. We didn't know until right now that Jack Smith was investigating the Ruby Freeman intimidation, assuming that that's what they were subpoenaing him about. Who knows? Maybe it could have been something else. But that is something that Jack Smith has been investigating for quite some time that we had no idea about. Again, just goes to the secrecy of the grand jury. And we also don't know if this Harrison Floyd person testified before the federal grand jury. I'm assuming he did, or he'd be in more trouble. But his docket has been kind of blank on that particular arrest for the last few months. There's been no indictment that we've seen. There's been no preliminary hearing. There's been no motion to delay a preliminary hearing pending plea negotiations. We haven't really seen anything. And so, could he be cooperating, or did they just not go after the charges because they were like, he's got plenty of other stuff going on? We just don't know what's happening with that case.
Yeah, so the interaction with the FBI agents allegedly occurred in outside of his residence in Maryland. They had been there, I think, once before, and they'd had some kind of aggressive interaction with him. You wouldn't talk to them or something. Not productive. They came back with a subpoena. They saw him outside the residence. They kind of followed. He argued with them, refused to take the subpoena. I think they followed him up a flight of stairs in front of his door to his townhouse or something. And then when he opened the door and went in, they threw the piece of paper in the door. So they turned around and left, and he then came out of his house all angry and screaming and yelling and shoved one of them, got physical with at least one of the agents. They leave. He then called 911 and reported an assault. I mean, it's just a whole kind of confusing, chaotic thing. So it looks like the agents got a warrant for him, and I would guess the warrant was based on a complaint, right? There's two ways you can get charged in the federal system, by complaint or by indictment. Complaint is just you write up the affidavit, you and the prosecutor, and then you go in front of a judge. The judge reviews it for probable cause. If they find there's probable cause, they sign an arrest warrant. You go out and arrest the person. You bring them in. They are, of course, in the federal system, you're arraigned the day that you're arrested. And at the arraignment, they set a date. You must be indicted by, I think it's 2 weeks after you've been arraigned.
Yeah, 30 days,
30 days.
I think. I've heard, yeah.
Whatever. You can also waive arraignment at the indictment, which many people do. So my guess, and it's total guess, what happened here was, I would think they secured an arrest warrant based on a complaint, and then for whatever reason, they never executed it. It could be just they didn't get around to it. It could be that he left the area, because we know that he moved to Georgia at some point in this, following that interaction. So if he goes to Georgia, it's not a big deal. It's not a very high priority thing that they're working on.
I think it's a misdemeanor in the
a misdemeanor warrant.
They put it in a misdemeanor warrant.
Yeah. So they're not going to send out a SWAT team from the Atlanta FBI office to find this guy and drag him in, get him arraigned in federal court, extradited to Maryland, because they had other things to do, obviously. So he's just in Georgia, and there's this existing federal arrest warrant. He probably doesn't have any other interactions with police. Had he been pulled over for speeding at that time, when the cops run your name through NCIC, they would have seen the outstanding warrant and taken him to jail. In this case, that probably happened when he went in and surrendered on the Fulton County case, and that's why he ended up getting held. So because he's never really been processed in the federal system on that arrest warrant, it's probably still just an outstanding warrant. That's why you're not really seeing anything on a docket, because the case isn't really started yet in court, because he's never been in there.
Got it. All right, well, we'll keep our eye on it for you for sure. All right, it's time to head down to Florida, but we need to take a quick break. Everybody stick around. We'll be right back.
Welcome back. All right, let's head down to Florida for some news that went under the radar this week. Last week, we talked about the Garcia hearings, or conflict of interest hearings, from Jack Smith for both Stanley Woodward and John Irving. You'll recall that Woodward represented Taveras and is still representing Nauta. And we also discussed a pleading that Jack Smith filed outlining the details of why there's a glaring conflict of interest, including that Taveras changed his testimony as soon as he removed Woodward as his counsel and accepted a public defender. Well, Woodward responded to that filing, complaining that Jack Smith publicly discussed things from a sealed hearing in D.C. without permission. Can you believe it, AG? Jack Smith violating the rules just like that for no reason.
What a dick. Like, I can't even believe Jack Smith. I mean, he's so sloppy that I wasn't surprised that he just pulled this, grand jury information, unsealed it and just put it up on the public docket. First of all, Jack Smith tried to file this under seal in Judge Cannon's court, and she denied that. Mm-hmm. Then Jack Smith responded to Woodward's complaint saying, dude, I made a request to disclose and I got permission and here it is, blah, blah, blah. This is from Judge Boasberg, right? Because this particular hearing, initially conflict of interest hearing, happened up with Judge Boasberg. That's when Judge Boasberg said, I am appointing a public defender. And that's when Taveras changed his testimony. Yeah. And so Jack's like, yeah, no, I got permission. You weirdo. Who do you think I am? Like, what do you think I'm
Rudy?
Yeah.
This is not Special Counsel Giuliani, okay?
Can you imagine? That might happen. Please vote, everyone. So, yeah, he showed the receipts, and that was the end of that. But then, by the way, in this filing that Woodward made, this complaint that, Jack Smith just did this, without permission, he disclosed that Trump PAC money went to pay for his representation of Taveras. So that's fun.
This is classic because it's so similar to the prior complaint that they levied about Jack Smith saying, hey, look, he tried to schedule jury selection in the D.C. case for the same day that there's a hearing in Florida, a big conflict of a whole day. And, and now here we have another completely hollow complaint. You just wonder, any rational judge with a lot of experience, having dealt with whiny, complaining lawyers all day, would see this stuff for what it is. This is nonsense. Stop complaining to me. Just kind of blow it off. But you really got to wonder if Judge Aileen Cannon sees it that way. That's a harder one to tell.
Yeah, and we'll soon know. We haven't got a ruling on these Garcia hearings yet, but of course, we will keep you posted when they do happen. And something else interesting that happened that I haven't seen reported anywhere. I had to go dig this up off the docket. But Carlos de Oliveira, who is superseded with Trump and Nauta for their conspiracy to delete security footage, right, with Taveras.
Yep.
That's the superseding indictment down here. He has filed for a speedy trial. He wants to begin in October. And this is interesting to me because we know down in Georgia, Cheese Bro and Sydney, Cheese and Kraken, as we call them, have filed for speedy trials, along with a few other people, and maybe to break it up and make it more difficult than to present your case all at once. But he's asking for this speedy trial, where Trump does not want a speedy trial. The rest of the trial is set to go May, right? Because the classified documents case and the superseding indictment for this obstruction are all in the same case. And this isn't a motion to sever either. So I don't know. What do you make of this?
Really interesting and kind of fascinating that no one else picked up on it. So major props to the person that brought it to our attention. On its surface, it seems like maybe this is a sign of a little bit of splintering between de Oliveira and Trump, right? Because it's having a speedy trial is clearly not in the interest of the Trump defense team. They want to slow everything down. So de Oliveira coming in and dropping this little bomb certainly doesn't seem consistent with that. But, it's a house of mirrors, so you have to look at everything from every side. And maybe this is intentional. And maybe
the
Trump team likes the idea that de Oliveira maybe gets severed and goes first on his own. They get a preview of the evidence. They get a preview of some of the government's witnesses, that sort of thing. Interestingly, it's a little bit different than the Georgia case because in Georgia, the state law is very absolute on this issue of speedy trial. If you request it, I think the state law is that you have to be put on trial before the expiration of the next quote unquote court session. The court sessions are generally about every 2 months. So the prosecutor and the judge don't really have much discretion as to, once the defendant claims speedy trial under Georgia state law, it has to go by this accelerated date. I don't believe that it's quite as absolute in the federal system. I think the judge still has a fair amount of discretion to balance the interests of the other defendants and ultimately to serve the interests of justice in the trial. So we'll have to see how this goes. It could provoke some sort of a severance of de Oliveira, maybe even de Oliveira and Nauta. Further complicated by the fact that they're all represented by the same two guys, it seems. So I don't know. It's love to be a fly on the wall in those joint defense meetings or phone calls, but there's something afoot here.
Yeah, and Jack Smith could file an argument against this speedy trial, saying, "Hey, this is a superseding indictment on a SEPA case. We don't have time to get to this." Or, maybe the judge canon decides to sever the superseding indictment from the main indictment, which would have no SEPA considerations and could go faster. But then Jack could argue, well, then they all have to go at once.
Right.
And so, we'll see how this ends up. But it would be interesting to see Jack Smith argue against a speedy trial when he's arguing for it elsewhere. But I don't know. It's hard to tell what Jack Smith is going to do in this particular instance.
Yeah, we're going to have to watch this one closely.
Yeah, and we definitely will. All right, we've got to address some concerns about Republicans who want to defund the investigations and investigate the investigators. Yeah, I'm super scared, shaking in my boots. Because this has been so successful in all of the other going back to Mueller investigations.
Yeah, it's worked in. It worked in. Or wait, that's right. It didn't work any of them.
Yep. Didn't
Hasn't
work
worked yet ever. But, okay.
And we talked about this early on in the show, but we just want to reiterate it. And Shalil Kapoor has put out a piece to remind us for NBC, and we want to talk about it, but we have to take a quick break. So everybody, stick around. We'll be right back. All right, everybody, welcome back. Since there are growing concerns again about a possible government shutdown, thank you, Republicans, I thought it would be a good time to remind everyone, as we did in one of the first episodes of this podcast, how difficult it would be, if not impossible, to shut down the special counsel investigations. As a matter of fact, a government shutdown would not halt the criminal proceedings against the former president. Again, as I said, this is from Shalil Kapoor at NBC. Trump's indictments in New York and Georgia would not be affected by a government shutdown, while his federal indictments are criminal matters that have been exempted from shutdowns in the past. The Justice Department said in a 2021 memo that during a shutdown, quote, criminal litigation will continue without interruption as an activity essential to the safety of human life and the protection of property. That's the Justice Department's plan, and it assumes that the judicial branch remains fully operational, which it has said in the past could carry on for weeks in the event of a funding lapse. And as I have said breathlessly since the Mueller probe, and again at the beginning of this podcast, Special Counsel Jack Smith's office is funded by a permanent indefinite appropriation for independent counsels from the U.S. Department of the Treasury, and that's what it said in a statement of its expenditures. Given its separate funding source, Special Counsel would not be affected by a shutdown and could run off all allocations from previous years. So this, let's see, we've got Rep. Andrew Clyde, Republican from Georgia, Trump ally. He's on the Appropriations Committee, and he said Monday he will introduce 2 amendments to eliminate federal funding for all 3 of Trump's prosecutions, Jack Smith, Fani Willis, and DA Alvin Bragg in Manhattan. Matt Gaetz has said he's pushing to cut off funding for Jack Smith specifically, and House Judiciary Committee Chair Jim Jordan is publicly calling for party leaders to insert provisions into government funding legislation that changes how the Justice Department can use money. So he probably wants to stop that fully funded U.S. Treasury thing from even existing. Now, You're going to have to get it past shit like that. You got to get past the Senate and you got to get Biden to sign it. So no,
that's not happening. No, not at all. And that standard that you referenced, so activity essential to the safety of human life and the protection of property, that's the standard that I assume the whole government, but my experience is only within FBI and DOJ, but it's the standard they use to determine essential personnel, people who have to continue coming to work even if there's a full government shutdown. And you're not getting paid during that period, but you still have to come in and do your job. And so folks on the kind of criminal side of the house, investigators, people who are essential to the continued investigation and prosecution of criminal cases, they are all always declared essential personnel and they keep coming to work.
And also if you shut them down or shut down the judges, you are infringing on speedy trial rights. I mean, there's also, it's in deference to criminal defendants and their rights as well.
That's right. That's right. So
when I worked at the VA, we were going to shut down hospitals? No,
yeah.
we're considered essential. And
Exactly.
so we weren't furloughed for that time.
Exactly. Yep. Yeah. So I don't think we have too much to worry about here.
Yep. Nope. Nobody worry. And I know this isn't part of our purview, but the Fani Willis new Georgia law where they can have a commission to have her impeached or removed as the DA. We now have the Speaker of the House, Republican. We now have Governor Brian Kemp. We have multiple high-ranking Republicans in the state saying that's
not going to happen.
It's not going to happen. So they might yell and scream and try. Like Matt Gaetz could probably put forth a resolution. It's not going to go anywhere. Same with Georgia. So I wouldn't concern myself too much with these little bits of fear that are out there to elicit your emotional response and make you angry.
Sound and fury signifying nothing.
Yes, life is a tale, and told by a drunk Rudy. Full of sound and fury, signifying nothing. All right, listener questions.
All right.
What do we have this week?
We have a really interesting one from Rob, who sends in from Cornwall, UK. And Rob says, "Hi, Allison and Andy. Thanks for a fascinating podcast. Really enjoying it here in the UK. My question: as Trump's counsel Lauro declared in court to Judge Chutkan that a March trial date means he cannot represent his client properly, what is to stop Trump from waiting until mid-February and then sacking his defense team, citing this declaration? Wouldn't this mean a de facto trial delay of many months? Is there anything the judge can do in this scenario? And if not, what's to stop Trump from just doing this again, approaching any new trial date? Cheers."
That's such a good question.
It is a good question. And on its face, it seems like it would be a great strategy for delay. So you could just count on the fact that this will happen at some point.
But someone's thought of it before, and
That's
so
right.
there are protections in
That's
place.
right. Even for someone like Trump, who so quickly hires and fires lawyers like right and left. So what would happen in this case if Trump tries to fire Lauro in any period, running right up to the trial date? Lauro would need to get leave of court or permission of the judge to actually stop representing Trump. And then Trump would have to add additional counsel. So that's how that would have to work. So that what would likely happen is the judge would not permit Lauro to leave. Now, Trump can say, "Lauro, you're fired. I don't like you anymore." But it's very different from the judge's perspective. She can require Lauro to continue to represent Trump. Now, what she would probably do, I think, in this under these circumstances, she would deny Lauro's request to terminate his representation of Trump, but she would probably also allow Trump to bring on another attorney if there was some other attorney that he preferred in that moment. And she would probably give that attorney some very minimal period to come up to speed on the case, realizing that it's not quite as hard to come up to speed because Lauro is still there helping him call the shots. So yeah, you would probably get a minimal delay out of it, but it's unlikely that it would be used successfully to delay the trial for months and months and months. Either way, the strategy is really designed to create an issue on appeal. Trump wants to be able to go back after he's convicted, go to the appellate court and say, "I was denied my preferred counsel. The counsel I had was insufficient, so I had an ineffective assistance of counsel appeal. And he wants to just layer in as many of these arguments on appeal to fight any sort of conviction he might get stuck with. And that would these would certainly add to that list, but probably they'd be unlikely to succeed.
Yeah, and we already know that this team is making considerations for appeal and sort of operating under the assumption that, that Trump is probably going to be convicted in this case, because we talked about them, wanting to refer to the Electoral Count Act as ambiguous and vague, much like the Ken McDonnell case that Jack Smith brought that was overturned by the Supreme Court because they found that the corruption statute for bribery was vague and overbroad and weird, and now you can't prosecute anybody for bribery because of that. But
thank you.
That I really truly think that they are really sort of lining their ducks up for appeals here, and that's why he went on the record at the end of that sentencing hearing to say, "You are infringing on his Sixth Amendment right. You are doing this. You are making defense impossible." And that's why this question was sent in. So really good question.
Great question. And it really, you got to get back to the fact that Trump's defense strategy in this case is a political strategy. So that's why the emphasis on delay. So even he's figuring, okay, if I don't want the trial to go before the election, but even if it does go before the election, and if I get convicted, I'll stack up reams and reams of issues on appeal, and that will take a long time. And before that can be resolved, I'll run for president in 2024 and win. And once I win, I will either pardon myself or I'll have DOJ drop all existing or charges or, or they won't oppose any of my appeals or what have you, and just to try to eviscerate the conviction retrospectively. That's his strategy. So that's why you're going to constantly see every little opportunity to take a day, to take an hour, to take a week back out of the calendar. Every little delay is a victory for them.
Yeah, 100%. All right, we have a new way to submit questions to our show. I believe there is a link in the show notes for a form that you can fill out. So if you have a question for us, please use that link to send us your questions. We appreciate that. We were losing too many, even with the Jack in the subject line. It was getting, sometimes people put other things in the subject line and we're getting filtered out. And then we would also, have 800 million other emails with the word Jack in them somewhere. So we have a form for you to fill out, and the link will be in the show notes. So we appreciate your questions. Thank you so much for sending them in. Everybody felt like it was a quiet week in Jack Smith land, but we ended up with another hour-long show, my friend.
There you go. Every time. It's going to keep happening again and again. We're 40 weeks into this, and I feel like we're just getting started.
Absolutely. All right, everybody. We will see you next week. It's been wonderful. Good to see you again, Andy. I've been Allison Gill.
And I'm Andy McCabe.
MSW Media.